when I'm getting to the bag, ayy. Got the foot on the gas, pedal to the metal when the lane moving fast, ayy, ayy. Let them all cross. If they hate, then let them hate and make a bigger boss, ayy.
What is up, ladies and gentlemen? We are back with This Week in Freight, powered by my friends over at DAT, you guys. This is 100% viewer submitted. We do this 3 times a week. We break down dry vans, reefers, and flatbeds, and that is what we are doing today, you guys. It is the flatbed lane analysis out there. And again, this is 100% viewer submitted. If you want your lane broken down in the show, I need you to email my team, podcast@thefreightcoach.com, put the shipping city, delivery city, and trailer type in there, and I will just show you lane performance. What do I mean by lane performance, you guys? I want you to be able to accurately read a freight market and how it performs over a 12-month cycle. Because frankly, you guys, the only thing that changes is the rates, right? Seasonalities remain the same almost every single year. Yes, there are some anomalies. Yes, there are things that happen that cause that, but you can usually go to some headlines and find out why did that happen, i.e. natural disasters, weather events, black swan events, stuff like that. It will tell the story, but you will also see how lanes perform year over year, and that's what's important. So this one, you guys, is San Antonio, Texas, going into Little Rock, Arkansas. Now, if you've never, ever bid on a lane before, the first thing I would advise you guys to look for is the miles. This one is 592 miles. So this is a great Monday through Thursday lane. Friday to Monday, you're going to see a price increase on there unless you find a driver who lives up going towards the receiver up there in Little Rock. But for the most part, you guys, this is a really good lane. It's held pretty stable since April, right? Like I look at my big indicators is I look at a $200 rate variance. Don't ask me why. It's just what I've always done throughout the entirety of my career. And it looks like this one has stayed between $1,800 and $2,000 since April. So for me in particular, this lane is as stable as you're going to find out there. But most importantly, you guys, it performed the exact same way back in this time of 2025. All right. And there's an increase here in September. And then it started to taper off in October. And then you can see the end of flatbed season, which is around the time the snow starts to fly in the northern part of the country. That pretty much signals the end of flatbed season. And that's usually in November. But this lane stayed very consistent all throughout that time frame last year. And I would expect that exact same thing to happen. You'll probably see a little bit of a price increase here in September. You know what that is for. It's going to be the Labor Day holiday. It's going to drive rates up, and it will show an elevated rate throughout the month. And then it will start to taper back off in October, and then it will drop down in November and December, which will be the end of flatbed season. But, you know, most importantly, you guys got to look at this as a 12-month cycle, because the rates are the rates. All right. Like nobody sets the rates. The market dictates it. In its simplest form, you guys, it's supply and demand out there. But the lanes will perform the same, at least from my perspective, almost every single year, outside of a couple of key events, which I described out there. But this lane, you guys, there is enough capacity that is going to be running on this one. It's going to remain probably this stable for a while. I would not hesitate to offer consistent pricing to my customer. If this was my flatbed customer out there in San Antonio, Texas, which we do move a very similar lane to this quite often, this is a very accurate assessment about where the market is. But I would feel very, very comfortable in keeping my rates the same here moving forward, especially as we're going in through September, where you'll see a little bit of a price increase around the Labor Day holiday, but it'll taper back off out there. I look at this, you guys, as this is a very normal market. Things have stabilized across the board. Yes, there are some pockets that are still volatile at times, but this is a pretty normal market again right now. Rates are up. That's the only real difference that are out there. Sell on stability, you guys. Sell on consistency. Be the voice of reason for your guys as customers. Be the transportation professional. As someone who's seen this stuff happen year in and year out, you're going to stand out in the crowd, you guys, because a lot of people don't like to do that because it's easier to sell fear. I like to sell stability, confidence in the fact that we've been here before and we've done this. But that is This Week in Freight, powered by my friends over at DAT, San Antonio, Texas, Little Rock, Arkansas, for a flatbed. Now, let's get back into the interview. We're going to save the entire intro. You guys know what to do. I got a very special guest. I wasn't even going to be talking about this, but I've just seen so much stuff come out, and I always love having practicing attorneys come on the show, inside of transportation, especially because, like, if you find yourself in a situation, you need to know who to reach out to. Obviously, nothing. He's not your attorney. Don't take anything we say of legal advice. If you need an attorney, contact an attorney. But I like having practicing attorneys come talk about hot button issues out there, because, like, this is a very real thing. So I want to welcome my friend, Mr. Bryan Nelson, back on the show. Bryan, you're like my resident legal expert at this point.
Hi, man. I love it. I love talking to you. Any chance that I get to talk about this stuff, except to my daughter, who will absolutely roll her eyes. So if people are engaging, it's great. Otherwise, I feel like I'm just talking at people. So if I can talk with people, much more excited to do it. And someone, who obviously has their finger on the pulse of what's going on, someone like you, it just makes it that much more entertaining. It makes it much more valuable. And especially to have someone that can, question, our thoughts as attorneys. Attorneys can question the thoughts of, our participants in the industry. There is this kind of give and take that type of engagement is extremely valuable, because nobody's going to listen to everything I say. No one's going to agree with everything I say. That's the whole point of attorneys. All the other attorneys generally that I fight against, whether they're plaintiffs' counsel, whether they're other attorneys representing transportation companies against my transportation companies, there's going to be disagreements in how you view and how you interpret or apply the law. And clearly, juries fit into that mold, because they will interpret things much differently than the way you or I would. I would like to think that I would not be biased, but I know I don't mean to kind of jump the shark here. But if I told my wife, if I ever die, I don't think I'm worth $200 million. Yeah. I'm gonna throw it out there. Like, don't hold out for that. Like, get something else. Like, don't be holding out for 200 million. Like, that's wild.
Yeah. Take the life insurance policy and run. Don't have spend as least amount of money on litigation as possible, and get your money and run. And ever since the whole thing came down in the Supreme Court a couple months back here, I had been kind of holding out, and I have always said I'm waiting for the next case to come out, right? Like, I'm waiting for the next one to really formulate an opinion on how the industry is going to change moving forward. And, now obviously this is going to be appealed possibly up to the Supreme Court, right? Like, this is not going to be settled anytime soon. Just outside perspective, outside looking in, I don't think C.H. Robinson's going to roll over and be like, you know what, here's $604 million.
No, they've already identified that they're working on the appeal. I think it might have even been filed, but they haven't. Mm-hmm. They're not going to sit back and let this go in.
So what was the dagger, we'll call it. What was the dagger that they, even though C.H. Robinson was like 23% at fault, what was the dagger that made them take on seemingly 100% of the settlement amount?
So let me actually kind of take a step back, because that percentage wise, they actually looked into, was the driver or any of the other drivers at fault, and the driver of the tractor trailer, was he 100% at fault, right? So they apportioned percentage of fault. Now, it was more than 50% of the fault went to the driver of the tractor trailer of the motor carrier. And so we're talking about, okay, well, now that they're over, different states have different rules and different applications of whether you can be liable for, hey, if you're more than 50%, are you liable for everything? Or if you're more than 50%, are you liable just for your portion? And when it comes to defendants, then you kind of have a similar argument, right? So are you liable for the entirety of the amount once you're over a threshold? Well, if you're in Texas and you're over 50% as the defendant of the fault, then you are jointly and severally liable for everything, meaning they can come after anybody who was listed on that side of the V on the complaint. And so here, would you say C.H. Robinson wasn't? But because of the questions that they ask and how they apportioned it, and this is what I talk about to a lot of shipper clients all the time, right? And when I'm talking to brokers and I'm advocating on behalf of my brokers, when these contracts are saying you're going to do all these things for the motor carrier, right? You're going to insure as opposed to contractually require. You're going to oversee, manage. You're going to discipline. No, we're not going to do any of that, because what happens here is we then get merged, and this case is a great explainer of the fact that you can get merged and then you lose a level of protection, right? So if I'm a shipper and I hire a broker and a carrier, I'm thinking carrier's insurance, broker's insurance, two walls before it gets to me. Well, the court just said, no, they're the same. Mm-hmm. And now you're going, wait, what? And some insurance policies aren't written so clearly, and so they can get merged. But in terms of going back to your question about the dagger, I want to read something because it's not a published opinion. Mm-hmm. We don't know what specifically the jury hung their hat on in terms of, oh, this is definitely why they controlled. This is why they were overstepping their bounds and became, as they said, a borrowed employee of the motor carrier. Well, I want to read this because I think this is important. You have C.H. Robinson came out and said, hey, listen, this carrier has done 270 plus loads with us. They have a satisfactory safety rating. They got re-rated after the accident as a result of the accident, and were still found to be satisfactory, right? And so you have kind of, and then they say he was, at no point do we operate vehicles and we were not the employer of the driver. So that tells me, okay, we're talking about control aspect. We're talking about vicarious liability, respondent superior. That is essentially the master is responsible for the actions of its servants, but essentially obviously now we don't have servants, we have employees. So the employer is responsible for its employees. And so that was okay. And then I read the plaintiffs, the attorneys, what they set out into the world. They said, giving a little bit of description of the accident. And they go, at trial, jurors learned that the federal regulators had flagged Lupus Superior for unsafe driving for more than a year before the crash, and C.H. Robinson hired the company anyways. So that gets us to negligent selection. Mm-hmm. And that's based on one single basic score. And then on the night of the crash, the driver told both companies he was too sick to keep driving. Instead of rescheduling, C.H. pressed him anyways. So we have a potential driver coercion issue, and we have negligent hiring or negligent selection based on a single basic. When you read the Montgomery case, they rattled off, hey, they're conditional. They rattled off all the basics or all the critical violations they found in the safety audit. Here, plaintiff's counsel could have blasted everything. Now, again, I don't have what they were in 2021. I don't have access to SAFER anymore, what it was. But assuming that it was only a single basic, most of the things that I'm reading, most of the things that I'm advising my clients as to what a reasonable carrier selection policy is, based on all the other factors, being strict as we can be, right? I'm seeing, even the ones that I'm not advising on, I'm seeing regularly from 2 to 3 basics can be acceptable, right? With a further review of certain key aspects. But if this is the case and they say, hey, listen, it's one basic, it's unsafe driving, right? Unsafe driving, as you know, covers, driving while holding a cell phone or driving while talking on a cell phone, holding some other handheld device, speeding, improper lane changes, right? So you have any of these aspects from an unsafe driving, they're saying, hey, for a year, they were elevated. That's the way I read that. And so when you take C.H. Robinson's case, C.H. Robinson's statement, it makes it seem like it's just, hey, we controlled the driver too much. And that made them say, hey, their employer, as you can see in the third, I believe, jury question that says, hey, was this company was this employee a borrowed employee? And then the fourth one, I believe, said, hey, was this in benefit and furtherance of C.H. Robinson's business? So I don't know what the dagger is, but I believe we're teetering both on negligent selection from a standpoint of the unsafe driving to vicarious liability because we did too much control. And the guy said, hey, man, I can't do this. I'm too sick, and kept pressing anyways. And let me kind of just real quick address the driver coercion rules, because a lot of companies don't know what driver coercion rules are. Yes. There's essentially 3 elements to a driver coercion complaint. And the FMCSA has a hotline essentially where you can make complaints, but it applies to anybody along the supply chain. It's generally to protect drivers from carriers, from their own employers, from forcing them to do things. But it can apply to brokers, it can apply to shippers, anyone up and down the supply chain. It says you ask the carrier or the driver to perform some action. The driver tells you that some action, and they don't need to give specific reference to regulations, but they need to say that, hey, doing so could result in a regulatory violation, right? So if I'm super sick, right? I'm not in the ability. I'm telling you, I am not able to control this vehicle.
Mm-hmm.
And then the third thing is you have to threaten the business of that driver, meaning, hey, you'll never get a shipment from me again. Hey, I'm going to deduct you if you don't get there in time. Those all are indicia of control. And that, depending on, and I don't know from here, what did they say to him? They pressed him to go on. Were they, come on, man, can you just do it, please? Or was it, hey, man, if you don't go, we're going to fine you and you'll never do business with us again. Hey, that 270 loads, it's gone. I don't know. I don't know what the ultimate final dagger was, but we have some breadcrumbs here that'll be interesting upon appeal.
So do you think, knowing, like, I don't know if the phone call was recorded, if they have any data. So do we know specifically at this time what that rep from C.H. Robinson said to the driver after he had said he wasn't feeling good?
All we have is what C.H. Robinson said and what the plaintiff's counsel has come out and said. So we just have we have press statements. That's all we've got. So
to essentially clear up any confusion out there, I've seen a lot of definitive posts that C.H. Robinson said that the driver must continue to drive. So that is false. All of that is false. We do not know. It could have happened, but we don't know for a fact.
That is what the plaintiff is claiming. The plaintiff claims that this is what I said. I have not, if there is a recorded anything through discovery, I have not seen it. It could have happened, but it could not have, correct?
For sure. So I guess my thing is in that moment, because I look back over my career, there have been drivers who have been ill, like visibly ill. They might not have came out and said, hey, I'm not feeling well, but they're coughing, they're sneezing, all of that stuff. And it's on the phone when I'm talking to them. Do I, in that moment as a broker, am I exerting too much control by asking anything in that moment? Am I treating them as an employee in that moment? What do I do here, man? Because it's like, I look at a lot of this stuff and there's conversations that are had between brokers and carriers all day long for multiple different things, load updates, all of that stuff. And I understand you cannot directly tell the driver, you can only do this or else, right? Like I understand that. But if we hear somebody is sick on the phone but they don't say they're sick, are we liable if they get in an accident and then we knew they were sick and we should have told them to pull over? And then my second part of that question is me telling them to pull over and stop driving, overstepping my boundary as a broker.
All right, let me go as I generally do, not answer your question directly and walk around it and then get to it at the end. Okay, perfect. What we don't know is how much the jury cared right now, right at this point. We don't know how much the jury cared about the 270 loads.
Yeah.
The plaintiff's statement talks about it, but doesn't make it a huge issue.
Yeah.
C.H. Robinson says this shows we used this carrier. He did a great job. There's never any incident. We had no reason to believe that there would ever be an incident, right? A logical argument. You and I are like, yeah, I want people with experience to handle my shipments. And if this person has 270 shipments worth of experience with me, I'm feeling good about hiring this carrier.
Correct.
Right? I don't know if, and let me be clear, if when you are hiring a motor carrier as a broker, most of the times, all of the people that I have worked with through my years inside brokerages, they want to get the driver on the phone because they want to hear it from the horse's mouth. Mm-hmm. Okay. They don't want to talk to the driver's dispatcher because they don't believe the dispatcher is giving them accurate information. They want to go directly to the driver.
Correct.
Right. And so you're cutting out. I'm not talking to the motor carrier now. I'm talking directly to your employee. Well, if we go to get it from the horse's mouth, at some point, Mr. Ed becomes our horse. Right. And so if we're saying, hey, we've used them 270 times. If it's that same driver every time, you know that dispatcher is like, oh, this driver's got it, man. I don't need to be involved. Just talk to him directly. So now all of a sudden I'm the broker. I'm calling the driver directly, telling him, hey, how's your day, man? What you got going on? Okay, can you get it here then? And now I'm just shooting him instructions. I'm shooting him or her. Hey, there's a claim. They call me directly as the broker. And I'm no longer utilizing the corporate formalities of the broker to carrier to driver kind of, flow chart, because I'm now going beyond that because I'm so familiar. That person knows everybody on the dock. They know how this product is supposed to be loaded, how it's really supposed to be secured. And so you're sitting here going, did the jury care about that? Did the jury care about how often they were there? And would that control have happened? Would that control narrative of the, hey, that's their borrowed employee? If this driver, and I don't know, they didn't get into the driver specifics. Did this driver do 150 of those 270 loads? Did they do all of them? Did he do 30 or 40 or 50 of them? Right? At some point, if this was, let's say it was a brand new carrier that had got on, the first time CH had ever done this, would there be that control aspect if they only dealt with the dispatchers and they had never talked to the driver? I don't know. Those are facts we don't yet know. And so from when I'm looking at this and I try to, my mind starts racing. My mind starts racing for all my clients and all their different scenarios and all the different things that they want done. I go, oh man, like what's riskier, using someone for the 845th time or saying, hey, I'm sorry, I think we should see other people, and then grabbing a brand new carrier, and then that person's unfamiliar with the route, unfamiliar with the landscape, unfamiliar with the cargo. There's so many questions that are raised from just the snippets that we have so far.
So let's go to the SMS scores for a second.
Yep.
I heard the year 2014 thrown out a lot about, like, was that the last time there was any updates to that carrier specific SMS scores at all? Or was it just one that was in violation, or was it just the one that was like green? And because like, if for those of you who are unfamiliar, the SMS safety scores, if you go to the FMCSA's website, there are, I believe, 4 categories out there, and it's essentially a stoplight coloring system on there: green, good; yellow, maybe look at it a little bit different; red, bad. That is how it is all done. But I saw the year 2014 thrown out there a lot. Was that the last time the carrier safety scores were audited at all?
So let me kind of correct that statement. So in Safer, there is the basic scores. They used to have under the SMS methodology, which still exists. Let me be clear. They had everything that the carrier could see was made public. They said, hey, as part of CSA 2010, and I remember when this came out, my company was going through an acquisition of another company, and we were analyzing the basics. It was brand new, and I was giving advice as to why this matters and all this stuff. It was public, right? And it looked back 24 months, and it was somewhat of a snapshot of the last 24 months of those 5 basic categories plus accidents, and it gave them a score, a percentile ranking based on what they call the event, the event category. Or sorry, I'm blanking on the name, but they essentially, each basic has 5 classes, and they rank you based on how many violations you have with people with similar number of violations. So it's an event category group. And I know I'm saying that wrong, so apologies to anybody out there that knows is screaming at this podcast right now telling me I'm wrong. But they break them out into categories, so you are compared against like competitors, right? And so what happened is they put those percentages out there, and they said, hey, here's all the percentages, and you were into a percentile ranking. And obviously they said, hey, these are the cutoffs for when intervention will come, meaning, hey, the FMCSA is going to knock on your door. It was 2 were at 65%, and the other 3 were at 80%. And so what happened is they started saying, oh, well, do we look at these basics? Do we not? We don't understand what's going on. Some brokers started to. Some brokers like, we're not going to. We're going to stay with safety ratings only. And what happened is, and I akined it to this way, when they showed those percentages, if anyone who has gone through law school or any other type of school where they have weighted grades, somebody has to be the worst. Someone has to get the worst grade. Even if they're smart, they still have to get the worst grade. Yep. Think about the Olympics. Someone in the Olympics has to finish last.
Yep.
Somebody in a 100-meter dash. I'm not going to go up to that guy and go, dang, man, you're slow as heck. No, because they're faster than most people. My wife has her favorite phrase is, why don't they just have a normal person like in every Olympic game? Like just so we can see what normal people would do compared to them. Like there should just be somebody running the 100-meter dash just way far behind. Someone tries to do a triple jump, they're falling on their face. I just want to see what a normal, I'm not going to try that. That'd be really great. But I say all that to say, when they're ranked like that, somebody had to finish last. every time. And so the carriers are like, what are you doing to us? You're making us look like we're terrible just because within this category, someone has to finish last. We could all be really good, or we can just be right there. And so in 2015, what happened is there was a settlement. So there was an organization of transportation attorneys and other industry participants who sued the FMCSA and said, hey, listen, there are multiple reports, and even the government's own, I forget the agency that did an investigation, said, hey, listen, these scores do not correlate to crashes. It doesn't mean that if they have a high score, it will correlate in a high number of crashes. They said there's no correlation. Having this information out to the public is bad. And so what they did is they took down the scores from public facing. If you're a motor carrier, you can still sign into Safer and see what your scores are compared to other people, because it's ranking you. It's giving you a classification to say, hey, you're at risk for being investigated and getting a safety audit. The whole point of these scores was to prioritize motor carriers for safety audits. That's all it was meant. And so when you go into Safer and you look at a motor carrier and you go into their SMS, their screen, down at the bottom, that language was part of that 2015 settlement that says this information is not to be used for safety purposes. And this is what I thought both the Department of Justice and C.H. Robinson's defense counsel did not hammer enough. They didn't even mention it in the oral arguments to say, hey, listen, we were specifically told by the government not to look at this. The government told us on their website, do not use this for safety data. This is just for compliance purposes of us going in and investigating. And so now all of a sudden you say, okay, well, we have this data. And what happened is all these third parties, which the attorney Joshi said during the oral argument, said, oh yeah, we don't have enough resources, but there's third parties that give them all this information better than we can. And you're like, wait, what? And so what that did is that brought basic scores right back to the forefront, because all the platforms, right, your carrier Sures, your any other program out there, your highways, right, they have their own formulas, because the FMCSA took that away publicly. They have their own formulas using the old methodology to try to get it close. So they may be a little bit different, each one, essentially saying, hey, no, everyone liked these percentages. They want them back. And so when 2015, when they took them down, within a few months, all of these platforms had those percentages up in their own kind of calculation. So it's like they never went away. It's just the government's not providing them, and we're relying on third parties to give us. So we have these basic percentiles, and we're trying to still use them as if we can peek behind the curtain and see what the carriers are seeing. And we're saying, hey, we can't ignore this data, even though the FMCSA specifically told us, don't use this data. And that's where we are.
I guess, what is an immediate risk management audit brokers should run on their carrier selection strategy, their current setup carriers? Like what? Because like, I mean, anybody who's listened to my show for a long time understands that I despise the majority of the federal government and their just absolute inability to operate and throw themselves out of any and all liability from everything. It's fucking like, there will be a time in the future where they look back on our time right now and be like, that is the dumbest things I have ever seen. Like everything I'm hearing right now, and this is Chris Jolly's opinion only, is it's like they are now, just based on sheer incompetence, punishing good carriers. From what I'm seeing, is potentially fluctuating all of that stuff. But then like, it's almost making it damn near impossible as a broker to select a carrier now based on a lot of these scores, because it's like, I look at trusted in-network carriers as kind of like the shield, right? Like, hey, I've been using these guys for years. They've done hundreds of loads for me. They picked up on time. They've delivered on time. Their communication has been great. But now when I'm seeing this, and again, I'm not an attorney, I'm not a legal expert, I'm just a guy who moves a fuckload of freight. And I look at this and I'm like, what do I have to do now to protect my business, to make sure it's not me on the end of this fucking lawsuit going off of SOPs that have been tried and true over my 20-year career in this industry?
I think the answer is we will now have to increase carrier auto liability to, I think, 500 million minimum, right? I think that's the new answer, right? Like every carrier, we didn't want to move it up to 2 million. No, we're just gonna go straight to 500 million. Everybody needs 500 million. No, so the issue here is that, listen, I describe the court system this way. The Supreme Court are your grandparents. Your parents followed their rules explicitly, right? So those are our federal cases. And I know I'm dumbing this down, and I apologize. I like to use a lot of random analogies that make sense in my head that may not make sense somewhere else, right? And so you have your aunts and uncles, or all the federal courts, and then you have your brothers and sisters or your other state courts, and then you have kind of the lower level state courts, which are all your weird cousins, right? And this court right now in Texas, this has no precedential value anywhere. It sends shockwaves, and it's probably going to embolden plaintiffs' counsels. Oh, we can get this much. And insurance companies are going to go, oh my gosh, we can get this much. I'll talk about insurance companies here in a second, and I'll repeat what I said last time I was on your show. But this is your cousin, your weird little cousin going, no, 600 million, everybody's liable. And you're like, okay, come on, man. Like you're going to scare some of the other kids. Like you're going to scare some of the other courts. Yeah. You're going to scare some people in this industry, but there's no precedential value necessarily. And to be clear, Montgomery didn't create the value of this claim.
Yeah, for sure.
Right. We had been trending in this direction for nuclear verdicts requiring tort reform before this. All this did was it took away, right? A C.H. Robinson was 23% liable, and the motor carrier, I forget, what was it, 40 something percent, 45?
Between the driver and the motor carrier, they were public school math 77%.
Okay. So that's just the other 23 and 77. Okay. So, but I think the driver was somewhere.
Driver was 45%. Motor carrier was 32%.
Perfect. Yeah. Okay. Perfect. Yeah. And so what they said was, okay, we're push the driver out here. Push the motor carrier. You were responsible for the driver because you were using him as your employee. So even if we took out the negative or the negligent selection, negligent hiring part, right, where Montgomery was, we would still be in this for 45%. Now, granted, we would say, hey, it was only 45%. I'm sorry, 45% of 600 million is still a lot of money, right? So correct. Montgomery didn't create this matter. Sure. We have been trending in this as a society from a failure to get a grip on our tort reform for way too long. And I actually appreciate the fact that this number is so eye-popping because, and I know that the TIA is one of your sponsors, right? This should be driving up donations and engagement like nothing else. Listen, hey, government, you told us you didn't have enough people in this oral argument to hit everybody, to hit every motor carrier. But now you're telling me even the motor carriers you do review, it doesn't matter? Like because you gave them a satisfactory C.H rating? Why are you doing anything at all?
Yeah.
So for me, it would be don't do any roadside inspections. That's just going to hurt me. If you're telling me that your audit, so the whole point of roadside inspections is to build up so you can then prioritize people for an audit. And then you're telling me your audit doesn't matter? Then why should your roadside inspections matter? Don't publicize them. Don't track them. Don't do anything because your audit means nothing to me.
Yeah.
And that is extremely frustrating. And so let me kind of step back off the ledge. Let me take a step back. What can you do as a broker? Right. So let me kind of just.
I like that, Brian. Brian, keep on the ledge, brother.
All right. So here, what can we do? We have to be reasonable. This doesn't change anything post Montgomery that we've been talking about. Sure. Insurance companies are going to freak out. But it's almost like one of those people that freaks out, right? They're like, oh my God, and I don't mean to belittle this, right? Like, let's say a building catches fire, right? And let's say your dry cleaner was in that building. Oh my God, my pants were in there. Like you had one pair of pants. You're like, well, no. Like these people lost a hell of a lot more. Like they lost so much. I feel like that's what a lot of auto liability insurers are saying. They're like, oh my God, this is horrible. It's like, yo, you capped your liability at $1 million, whether it's 500 million, 400 million, 20 million, 15 million, you're only on the hook for 1 million. You're out. And they're like, oh yeah, you're right. It was just a pair of pants. Yeah, I'm good. Like, I don't understand why insurance companies are freaking out. Nobody insures at that level. Now, obviously C.H. Robinson and a lot of your publicly traded companies do. But for your average broker out there, they have 1 million to 2 million, $500 million. You just laugh at this point.
Yeah.
Right. You go, oh, that's hysterical. Yeah. You're not getting that. No, I don't think so. Right. And so your insurance only still pays the $1 million. That's what they were in for, whether it was a nuclear verdict or not. They said they'd pay $1 million. That's what I've been paying my premiums for. So that hasn't changed. And as a broker, you still need a reasonable policy. Now, what this case does for me overall is the concern that I have, because I think doing too much control, C.H. Robinson has had a number of cases over the years where they exert too much control. That has been a constant thing that they have dealt with.
Yeah.
My clients, and it's hard to separate them, right? Because they have tracking, they have, whether it's through ELDs, whether it's through macro point on the cell phone, right? We need to make sure we use our words appropriately, because words matter. Correct. I'm not tracking the driver. I have so many clients that say, well, I track the driver. I say, no, you don't. Do you care where that driver is? I was like, you don't care where that driver is. You care where that cargo is, right? You're tracking the cargo, and you don't need that. So if you're tracking the cargo and you have a GPS, why are you calling the driver? Call the dispatcher. Maintain those corporate formalities of broker to carrier and let the carrier deal with the driver, right? That's what you're doing. And obviously cargo theft and other things have made that a little bit more complicated. So everyone wants to get to the driver to verify they're a real person. Okay, once your verification that that's who's showing up, like it's no different than if I hired a company to come to my house. I still want to make sure that that person actually works for that company. I'm not just going to open my doors and let people in. But at that point, let them do their professional duty. And so the negligent, the thing that concerns me more is if it truly was only one basic score. Well, here we have causation, right? At least we assume so. They were bad for driver or for unsafe driving. And an unsafe driving appears to be what caused this. So that is your immediate causation that the Supreme Court was talking about. But if we have the control aspect, we need to take a step back and recognize and remember, we are brokers. We need to fight it on the carrier, on the customer side. When they tell us all the things that we have to do to the carrier, we say, no, we're not. Do you guys want to be exposed here as a shipper? Because they're going to be the next ones brought into this, right? They're going to be brought in.
Correct.
And so if they're deemed, hey, we're going to, guess what? If a carrier says that to us, hey, no, go after them. You better believe I'm going to point up as a broker. I'm going to point up to you and say, well, it wasn't us, it was them, right? They told us what to say, right? And so shippers need to be careful, and they're on the clock now too. And I will say this, anti-indemnification laws will become more and more important. And brokers, make sure you have in your language that, the negligence of the shipper, you're not responsible for indemnifying. Because if a court assigns liability or negligence to that shipper, you want to make sure you're not responsible for that portion. And most of these, C.H. Robinson has a target on its back because they're large. What is it? The higher you climb, the more you're exposed. That's where C.H. Robinson is. That's where other large brokers are. That's where large companies are. A number of my clients live in the same neighborhood as C.H. Robinson. They are up there. They are publicly traded. They are large. And I have to address the carrier selection policy a little bit different than for the smaller carriers, because somebody can't just close their doors. Whereas, you know what? They don't have a word for, I think I said this before, they don't have a word for a chameleon broker. That's not a thing. If you get hit with a suit, it may be beneficial to create a new business, right? And be prepared to say, hey, listen, maybe I need to start back from the beginning. I need to work my way up as an agent, right? And go that way. But you can start over and still own a business. Whereas if you're a motor carrier and you're an owner of a motor carrier and something happens to your motor carrier, you try to start a new business, you have all these things tracking you, and it'll be so much harder for you to restart and build up as a driver. You'll probably have to go back and just work for somebody else. And I know that's, entrepreneurs of the independent contractor model, they don't want to work for somebody else. And so it just makes it that much more difficult. Those barriers are not present to brokers currently.
Man, Bryan, I know you, but dude, like, no bullshit, everything. This is why I love having you come on the show, because you take the stance of like, this is not that you're actually defending your clients here, but like you take that approach to how you answer my questions on this show. Like if I was defending you, like that's the kind of the vibe that I get. And this is why I love having you come on there, because you're providing actual insight for people. And heaven forbid you're the defense attorney in one of these situations, man. Like this is why people need to listen to people who would actually be in that situation in the event that your client was, their number was called here, right? So it's like, I think people need to get off of Twitter, get off of the soapbox of some people on social media, and do their research out there, because like this case is still very wide open, in my opinion. Again, I'm not a lawyer. There's a lot of appeals that are going to be thrown out. This might be 5 to 10 years more of litigation before this actually gets settled, right? Like there's a lot more appeals.
Yeah, we got to, and something that one of my partners told me yesterday, Todd Rubenstein, who's a fabulous defense attorney with our firm, who is in the trenches with the litigation. I'm on the front end trying to prevent you from getting sued. He's on the back end when things have hit the fan, right? You know, he talked about this case, and what this case has done is it doesn't change the overall complexity or the valuation of the claim. What it does is it allows those smaller claims, because the fear of nuclear verdicts is just, it's always right there. It lets those smaller claims, unfortunately, sometimes creep into, you know, because we don't make the decision of settlement or not, right? A lot of times that's, you know, the client and the insurance company, right? Because the insurance company is paying the bills on a lot of these, and they say, hey, you know, they get into a conversation and they provide their guidance to the insured, and they sit here and they talk and they say, okay, well, this is, you know, this is what we think is reasonable. And what we find is that I think some of the settlement potentials have a risk of creeping up. You know, we try to talk to our clients and say, hey, listen, let's maintain calm, cool here. But because of this nuclear verdict out there, you know, maybe something that should have been maybe a $400,000 claim, clients are overpaying for it. They're like, oh, well, let's pay 600,000. Like, I don't want to like, they're expanding how much that risk exposure means to them financially. Mm-hmm. And so it's not going to change. And let me going back to the target point, C.H. Robinson being a target because they grew their business. They are the story, right? Everyone that maybe throws shade at C.H. Robinson. Yep. If you told me, if I told you, hey, your brokerage can be that big and you can be the owner of that company, you'd be like, okay, yeah, let's do it. Right. Like, yeah, sign me up. Like, everybody gets in this business to do things the right way, to support their families, their friends' families, all their employees' families. They don't get in this, right, to get into accidents or to cause people to get into accidents. And they get in this to grow and be successful and be able to support all the people that they love and care about that work for them. And C.H. Robinson is no different, right? Despite what you think, oh, they're mean, they don't treat so-and-so right, or they have this, you know, their employees are people too, right? And they have flaws, and everybody has flaws. And unfortunately, as we talked about, respondent superior, they have to be responsible for all the things that their individual employees screw up throughout the time, right? As any other employer. And so when we're sitting here saying, hey, listen, C.H. Robinson got hit with this, good, I don't like them, or hey, I don't like something that they did here, especially on the motor carriers, them taking this brunt, this should make everybody in the industry mad. Mm-hmm. It should make bad because, yeah, maybe it won't happen to you, right? Some of my smaller brokers, no one's going to come to them with 600. Like I said, they'll laugh. They'll just it'll be like Dr. Evil telling the 1960s, right? Like, give me $1 billion. They're going to go, $1 billion. Yeah, they're going to be like, okay, good luck. That's funny. Yeah, here are the keys. It's yours, man. I'm out of here. Yeah, that's not going to happen. So C.H. Robinson getting hit with this is because they had the big name. They had the big title, right? And so for a lot of my smaller clients, breathe, get the insurance company, stay the course, do the things you know that are right, do the things that are reasonable. You know, don't ignore basics, don't ignore out of service percentage, don't ignore, I guess you can ignore safety rating. Really, you don't need to look at that unless it just happened yesterday, right? I guess who cares about the safety rating other than stay away from conditional. That, you know, if that was me, anyways, that's what I would say. Again, not your attorney. Listen to your attorney. Let them do their own thing.
Oh man, dude, I love it, Bryan. I know you got to jump. You're at a conference. You got to get out there, man. Thank you so much for your time, as always.
Florida Trucking Association. It's honestly one of my favorite conferences. It's great because I don't know what other conferences do. No offense, like Wyoming Trucking Association, like. I know you don't, like, I'm in Fort Lauderdale on the beach right now. Like, I don't know any other state conferences that have better locations than Florida, man. I love our conference locations.
Yeah, man, you guys got all coastline out there, unless it's in Orlando, right?
Well, yeah, I mean, we do have a few Orlando ones. Every so many, we got to make sure we hit everybody. But whether you're in the Panhandle, man, South Florida, you know, West Coast, you know, St. Pete area, or East Coast, you know, St. Augustine, anywhere, man. I love the state of Florida, and our association is very strong. Got a lot of people here today, and they're all asking me the same things. Not as in depth as you just did, but they're asking me a lot of things, man.
Well, hey, man, I appreciate it. Thank you so much. And that's going to be it for today, ladies and gentlemen. We will be back on Monday. You know how we're going to roll. We're going to continue to bring the facts out there. We're going to talk to the right people to give you guys information that you can actually apply to your business. I appreciate you guys. I love you guys. And we'll be talking to you soon.
Came back with a bang. Window down, yelling out money, anything. Hey, ooh, got the foot on the gas. Pedal to the metal when I'm getting to the bag. Hey, got the foot on the gas. Pedal to the metal when the lane moving fast. Hey.